Okay, so I want to talk today about the legal prorogation of 2019, where Boris Johnson's first government, after he became leader, attempted to suspend Parliament, essentially in effect in order to try and force no deal Brexit through. Now, the rule is much misunderstood, especially by Brexiteers. So Brexiteers will say that the court was acting corruptly because they were attempting to prevent the government getting Brexit through, which was the will of the people. And the reason why that's a massive misunderstanding is that the government's entire defence was that this was nothing whatsoever to do with Brexit. This was in no way an attempt to force Brexit through. So if you as a Brexiteer are saying that the court was pro-Remain in attempting to prevent the government from getting Brexit through, you yourself are saying that you think the government's entire case is basically a load of crap and that they were lying through their teeth. And it's hard to argue then that a court is corrupt. Surely the corruption would be if the court nonetheless has said, we think you're lying, we think your case is a complete pile of crap, but nonetheless, we're going to rule in your favour. Anyway, let's look at what happened. So this is what the plan was. So the plan was that, on the 28th of August, they announced a prorogation, which was to take place sometime, I think it was actually between the 8th and the 12th, but eventually it was decided it would start on the 10th, run all the way through for about 5 weeks, through to the 13th, and then on the 14th, there would be a Queen's speech. Meanwhile, we had this looming deadline that on the 31st of October, if no deal had been negotiated, we would crash out without a deal. Now, there was plenty of issues with us eventually leaving with a deal, which had a transition period and all this sort of stuff, and I've gone over that in my original Brexit video. I think no deal would have been pretty bad. But anyway, so that's what happened. Now, this was immediately appealed twice. So I think Joanna Cherry and some people appealed in Scotland. But remember, Scottish law is separate from English law, following the Act of Union in 1707. And then it was also appealed in England under English law. By Gina Miller, and some others. Now, the Scottish case ruled it was illegal. The Scottish court ruled it was illegal. The English court, now, as much as people say the English court ruled that it wasn't illegal, that's not actually true so much as they ruled it wasn't justiciable. Now, justiciable basically means they're saying it's not a matter of justice. They're saying it's not a thing they're saying it might be terrible, it might be awful, but it's not a thing that actually laws exist that say whether or not it's a reasonable thing to do. So it was then, those rulings were then immediately appealed. In Scotland, it was the government that appealed, trying to overturn the decision it was illegal. And in England, it was the original people, Gina Miller and co, who appealed, trying to overturn the result, said it was non-justiciable. So it went to the Supreme Court. Now, at this point, in order to understand the ruling, we have to understand the difference between a prorogation and a recess. This is really important, because one thing Brexiteers often say, well, they go for 5 weeks every autumn anyway for party conferences. So what's the difference? They're fundamentally different. So you first have to understand that our constitution has kind of evolved. And so parliaments originally weren't permanent. We tend to think of parliaments permanent now. That part of being a democracy means you have to have an elected legislature. If you don't have an elected legislature, then you're not a democracy. So we think of parliaments permanent, but it originally wasn't. Originally the kings had ultimate powers. And then by sort of the 1600s, there was a court case, I think cited in this judgment, something like 1606 or something, where it was ruled that the king does not have ultimate power. The king only has those powers that Parliament has passed laws, given those powers to the king. So you had, the king was the government, the king ran the country, the king took decisions, but it was actually now he now, it was the Queen when this all happened. I'll say the monarch. The monarch could only take those decisions that the law entrusted to the monarch. Meanwhile, you have Parliament. Parliament was the legislature. Parliament passed laws. But the king summoned a Parliament, and the king only needed to summon a Parliament if he needed new laws. So if he didn't need any new laws, and typically he needed new laws when he had a water fight and he needed new taxes. New taxes means new laws. So I think Charles II ruled for a decade or so without calling a Parliament, but then he got himself in a war in Scotland. He needed more money. He needed new taxes, which meant new laws. He had to summon a Parliament. That Parliament then got a bit rebellious, he lost control of it, and the result was the English Civil War. But so, Parliament was an episodic thing. The king would summon Parliament, and then when he would tell Parliament what laws he wanted them to pass, and then Parliament had done all those laws, the king would then dismiss the parliament. But remember, the parliament in this case, he would summon all the lords would come to sit in the House of Lords, and each city or each borough would elect 2 MPs, and each county would elect 2 MPs, and they would sit as the Commons. So we still have this concept of we have a parliament which is for a period of time. It's summoned. There's a queen or king speech that says this is what laws in this case it's the government. Remember, the government now is all the powers the king used to have, the government now has. So you have the king or queen speech, which is notionally what laws the king or queen wants parliament to pass, but it's actually the government. And then parliament will pass all those laws, and then that session will end and a new one will start. So in between sessions, you have a prorogation, and you have it for 2 reasons. So first of all, when you have an election, you have a 3-week prorogation, and that's closer to how it used to be. You know, the parliament is dismissed, and they go back to their towns, and the towns elect new ones, and so on, and then they all come back again for a new session, and they have a king's speech or a queen's speech. But then usually the session's set for a year, so every year it gets reset. So the king's or queen's speech will have a year's worth of legislation in it. At the end of it, they've passed all the legislation. Now they can pass obviously legislation other than what's in the speech, because you have emergency legislation like we have for COVID. But broadly, I think the convention is that it's like the agenda of a meeting. Broadly, emergency aside, you should only be passing that legislation which you put in the Queen or King's speech. And so at the end of the year, you have a 1-week prorogation to reset it. So you have 1-week prorogation, and then you get called back again. There's another Queen's speech or King's speech. I think part of the week is something stupid, like it takes 5 days for the ink to dry on the goat skin that the speech is written on. You know, it's been a very modern country. But anyway, that's a prorogation. Now, important thing to notice is that during a prorogation, Parliament ceases to exist. There is no Parliament. So it means not only can they not pass legislation, you can't debate, select committees can't meet. So select committees that could normally summon a government minister and question them under the threat of perjury and ask them to explain themselves, they can no longer meet. Also, any legislation which was halfway through, if you had legislation which was halfway through its various stuff, that's thrown away. You have to start again. It's all gone, reset. And Parliament can't re-summon itself. I mean, it can't. If an emergency happens during a prorogation, the Speaker can't recall the House of Commons or whatever, because there is no House of Commons. It ceased to exist. A recess, meanwhile, is something that happens individually to the House of Commons and the House of Lords. And it's basically within the chamber, they propose a motion that says, let's adjourn until such and such a date. And they vote it through and they adjourn. But crucially, first of all, it's done separately for the Commons and the Lords. It's done by the houses themselves. So whereas prorogation is something that's done the government does to Parliament, whether Parliament likes it or not, a recess is each chamber votes it through. And crucially, the Parliament still exists. So if an emergency happens, the Speaker could just recall, like the House of Commons, they could debate stuff. But also, if select committees have some meetings lined up, they can still have their meetings, they can still summon witnesses and so on. They can still put written questions in to government ministers, which they can't do during a prorogation. So normally, during the autumn period, they do have like a 3-week recess in order to have the party conferences. The point is, during that period, they could still meet a select committee. So the Brexit select committee, which shadowed the Brexit department, could still ask questions of the Brexit minister. They could still put in written questions to ministers. And crucially, they could not go on recess. Now, the point is, no one seriously believes they wouldn't have gone on recess, or not for 3 weeks. There's nowhere on earth, when we were facing an absolute national crisis, there was nowhere on earth a House of Commons that was very worried about this was just going to swan off for 3 weeks. It wasn't going to happen. So it's clear to anyone that the reason why the government wanted to do it was they knew Parliament wasn't going to go into recess. They were scared that they were going to pass a law which basically made it illegal for us to crash out with no deal, which they eventually did. They passed a law that said if there is no deal, the Prime Minister is legally required to send in a letter to the European Union asking to extend our Article 50 sort of period, which they did. He had to do that. They accepted it. It was extended. So, but the crucial thing is, the governments, when they announced the prorogation, they didn't say that. What they said was, now, to go back in time a bit, if you remember, Theresa May has an election in 2017 where she thought she was going to get a thumping majority and destroy Jeremy Corbyn, and it all backfired on her horribly. She ended up actually as a minority government propped up by the DUP. And the thing is, a Queen's speech as it was then is actually a confidence thing. If you get appointed Prime Minister, you do your Queen's speech and then you can't get it through Parliament after the election, your government falls. So they were worried that a future Queen's speech could be a real problem if they lost their deal with the DUP. So they actually announced it was going to be a 2-year session. They put 2 years worth of legislation in his Queen's speech. Now, at the end of 2 years, so that would have been whatever, sometime, the spring, early summer of 2019, they'd run out of legislation, but they knew at this point they'd completely lost control of Parliament. So you'd had all the people with the MPs leaving and stuff like that. So they just didn't do another Queen's speech. The session just carried on as this kind of zombie session with no legislation to discuss other than discussing Brexit. So, I mean, it was true there was an issue there. So the government, when they called for the programme on 28th of August, they said, this is nothing to do with Brexit. There's more to life than Brexit. We need to go and discuss all the other things we want to discuss. It's really important to reset Parliament and have a Queen's speech. And they insisted, Michael Gove went on TV, insisted in no way was an attempt to delay Brexit. Anyway, so we get to the court case. Now, what the defence did was so the government's position essentially was that there are no legal limits to how long a government can prorogue Parliament. A government can prorogue Parliament. It's what's called the royal prerogative. The royal prerogative is things that used to be just stuff the king could just do, and now it's stuff that the government can just do. So their position was that there are no limits to how long a government can prorogue Parliament whenever they want, for however long they want. That was their position. Now, the defence started out by outlining, well, if that was true, what might the effects be? So, and I think the thought goes, imagine Jeremy Corbyn had got elected. And imagine he turned out to be the terribly hardline Marxist his detractors said he was. But I don't think he was. This was just like a thought exercise. But imagine he was some kind of hardcore mad Marxist. So imagine he got elected with a majority, Labour majority, so the Queen, makes him Prime Minister, and he immediately then prorogues Parliament for 3 years. So he can just rule as dictator. Now you could say, but the Labour Party could sack him as leader. Well, yes, the Labour MPs and stuff, they could get together under Labour Party procedures, they could sack him as leader, but he'd still be Prime Minister, wouldn't he? You don't have to be leader to be Prime Minister. Lloyd George was not leader of the Liberal Party when he became Prime Minister. You might say, the Commons could do a vote of no... What Commons? There is no House of Commons. He's prorogued Parliament. There is no House of Commons to vote him out. So they said, what would happen? One of the things, the British Army, for various reasons, isn't technically permanent. It's because when it was set up after the Civil War, every year there has to be a parliamentary vote to renew the British Army. So the British Army would cease to exist, which, as a lovely member of C&D, maybe Corbyn would like that. Anyway, the whole load of things. So at this point, we can generally agree that would seem to be a bad thing. If our constitution does allow you, as soon as you're appointed Prime Minister, you can just dismiss the people who can sack you for the years. Most people would agree, if that is the case, that would be quite a hole. That would be bad. But the fact that it would be bad doesn't mean it's illegal. And if our constitution allows that, then our constitution allows that, right? So this was where the court got to the bit where, if you're going to argue against the case, you can argue this was the bit where they extrapolated a bit too hard. And I can see how someone could reasonably, in good faith, argue that they'd extrapolated a bit too hard. This was the bit where the English court couldn't go. The English court stopped that point and said, well, yeah, that would be terrible, but there's no law that says they can't. Whereas the Supreme Court sided with the Scottish interpretation, which basically say that clearly prorogation can be legal because we do it every year for a week to do the Queen's speech, or the King's speech it is now, and then we do it for 3 weeks to have an election. But is an infinite prorogation illegal? And the argument they made is that the British Constitution consists of various parts. And one of those parts is the legislature, House of Lords, the House of Commons. And they have a few functions. Obviously, one of them is to pass legislation. Now, if they're prorogued, they can't pass legislation. The other one is to scrutinise and control the executive being the government. And they can do that by, they can write letters to ministers, which they can demand answers. They can summon ministers and the Prime Minister in front of either the Chamber, the Commons or whatever, or a select committee and ask them questions that they have to answer. And as an ultimate nuclear option, they can actually dismiss the government. They can get rid of the government. They can vote them out as vote of no confidence. And those are their constitutional roles. And if you were to prorogue Parliament for 3 years, for 3 years you would be preventing Parliament from carrying out its part of the Constitution. And the argument then that the court made is that, well, that's unconstitutional. It has to be unconstitutional to prevent a key part of the Constitution from actually fulfilling its constitutional function. So from that, they would say a 3-year-long prorogation would be illegal. So they were then able to craft a legal threshold as to what made a prorogation legal. And it is legal if A, it is for a reasonable purpose, and B, it is for a period of time that is reasonable, commensurate with that purpose. And this is the point where the government's case fell apart. The first, because you don't need 5 weeks to do a Queen's speech. You only need 1 week. Now, we can prove that because, look, this is what actually happened. This is the prorogation that was cancelled on the 24th. So it was ruled, the court ruled it never happened. And they then did a 1 week prorogation here with the Queen's speech on the 14th. So they only needed 1 week. They ended up, it did not in any way delay, the Queen's speech they said was what they wanted to do. In no way did it delay the Queen's speech. The Queen's speech happened on the date on which they wanted to happen. So that proves the point, they only need to do a week. So that's the first bit where it fell apart, was you didn't need to do 5 weeks, you need to do 1 week. But the other thing was the prorogation for a reasonable purpose? Now, remember how I said they'd insisted that this was in no way an attempt to stop Brexit? This was purely about they wanted to have a Queen's speech. Well, it's not actually unprecedented for someone to go to court to do some sort of judicial review or whatever to challenge a government decision. It was unusual for it to be as high profile as this, but it happens. But imagine, say, the RAF were building a new base and the Ministry of Defence put it out to tender. And a bunch of companies applied and one company got the tender to build this new airbase. And then it turns out that one of the guys on the board of directors of this company is the brother-in-law of the Minister, the Secretary of State for Defence, which, I mean, looks a bit dodgy. And one of the other companies that lost the tender went to judicial review saying this is not fair, they shouldn't have been awarded a contract. Now, let's say the government's defence was the Minister of Defence, Secretary of State for Defence, he didn't even know this was happening. It was complete news to him. He and his brother-in-law don't discuss stuff like that for obvious reasons. And that this decision was actually taken by a junior minister 2 levels down, the equivalent civil servant 2 levels down. It was completely fair. What you'd expect, and David Allen Green points to this, he did a blog post, I'll try and link it in a pinned thing about the Cures case of the missing letter. You wouldn't normally have people actually give evidence. What would normally happen is, in that case, the RAF case, the junior minister concerned and his equivalent civil servant, they would write a letter which detailed all the ways in which this decision was taken, all the meetings that were taken, all the points that were made, the reasons why they did it, whatever, complete timeline of how the decision was taken, and then they'd both sign it, and it would be submitted to the court as evidence. And crucially, this would count as evidence, which means if they'd lied, if it turns out they'd lied, it would be perjury and they could go to prison. And people do go to prison for perjury. I mean, John Aiken and Geoffrey Archer, in classic examples. So in this case, you'd expect someone to submit a letter giving all the chain of discussion as to why there should be a Queen's speech, when they should have it, what should be in the Queen's speech, how long, the timetable, how long prorogation needed to be, and so on. And all there was one memo. There was a memo, which was, I don't know, submitted. There was a memo from the private secretary or something to the Prime Minister saying, I think we should do a prorogation starting here, ending here, with no real mention as to why. And the conclusion of everyone, including the court, was that the reason why there was no letter was basically because any such letter would have been a lie, basically, because they were doing it to try and get Brexit through. They were trying to stop Parliament passing an anti-Brexit law. And whoever signed it could end up in prison, basically. So that was why the court concluded that when the government said, both at the time and in their, the words they supplied to their lawyers, when they said that the prorogation was in no way an attempt to stop Brexit happening, the court concluded they were lying. Which I think everyone thinks they're lying, but that was the crucial case why. So they failed the legal threshold on 2 reasons. A, it's not reasonable to do a 5-week prorogation for a Queen's speech. And B, no one actually thinks that was why they're doing it anyway. They're doing it to try and stop, to force a no-deal Brexit through. The point being, I should say, is this would have left, the original thing wouldn't have left enough time. Even if had they negotiated the deal, there would not be enough time there for Parliament to scrutinise and accept the deal. So this was just a side. This was why, if you saw the headlines that Jacob Rees-Mogg lied to the Queen, this was the conclusion of the court. The point is there's 2 alternatives. So Jacob Rees-Mogg flew to Balmoral and said to the Queen, Your Majesty, we, your government, recommend that you prorogue Parliament. And she said yes. I mean, she has no choice, really. I mean, that's the way it works. No, but there's 2 ways he could have said it. He could have said, Your Majesty, we need to get Brexit through. It's the will of the people. Parliament's going to pass a law that forces us to apply for an extension. We want to stop that, so we're going to prorogue Parliament for 5 weeks. But obviously that'd be really bad if we said that. So we're going to tell everyone it's because we've got lots of legislation on housing rights and tenants' rights and stuff that we want to pass. That's option one, which would mean the Queen colluded in a lie to the British people. Or option two is he told her, he didn't mention Brexit, just said we need to do a Queen's speech, it's been 2.5 years now, we've run out of legislation to pass, etc., etc. In which case he lied to the Queen. So the court concludes on the balance of probabilities, they thought he'd lied to the Queen rather than the Queen had colluded in a lie. And so that was essentially the decision. I mean, finally, the court also then ordered, the final government defence, last defence was it doesn't matter if the reasons, the order for the prorogation was illegal. They said the order still had been read out in each chamber. So it has happened, which was true. I mean, I think the MPs complained at the time they were protesting. But what the court said was that since the order was illegal, I think they said, is it the official concerns, if the official concerns had walked in with a blank sheet of paper that meant nothing. So they literally said the prorogation simply had not happened. And the House of Commons was free to start meeting whenever it felt like, essentially. The government didn't have to do anything. So that was it. I mean, for what it's worth, I think it was the right decision. I think it would be very bad if a Prime Minister could just dismiss our legislature for years and years and years, and be unsackable. I think that'd be a very bad thing. I can see that you can argue it was a bit of a stretch to create the legal threshold, but I personally don't think it's unreasonable. But you certainly can't say that it was a corrupt court that was, frustrating the people's will regarding Brexit, because even the government itself insisted in their defence that it was nothing to do with Brexit. So, anyway, so that was the prorogation of 2019, both the 5-week one that didn't happen and the 1-week one that did. Hope that clears things up and all made sense. Thank you.